Case of Gina Carano versus Disney, I know there's a lot of confusion out there, and myself included with some of the news last week because it gets into some of the more detailed nuance of the law. And of course, I'm not a lawyer, but thank God we have a good friend who is a fantastic lawyer, Ron Coleman from the Coleman Nation podcast, here to talk about what exactly it was that Disney was asking this judge to do in the Gina Carano case, and probably why that judge said no. Disney denied an early review of Mandalorian actor bias suit. So this is from Bloomberg Law, and effectively Disney lost its bid to get an immediate appellate review of former Mandalorian star Gina Carano's discrimination lawsuit. Disney's request for immediate review by the U.S. Court of Appeals for the Ninth Circuit, we can talk about that as well, over whether the First Amendment protected its ability as an artistic entity, or some might say autistic entity, to make casting decisions by removing someone whose advocacy harmed its own expression isn't purely a question of law, said the judge for the, I think the lower court, Judge Sherilyn Peace Garnett. So, Ron, what is this? Because this seems like, my understanding, this is a bit of an unusual move to do, and kind of walk us through what happened here.
What happened here is what always happens when people ask for interlocutory review in the federal court, almost all the time. So let's take a step back. In many state courts and in all federal courts, you can only review a final order or a preliminary injunction. In other words, you can only appeal, rather. An appeal court can only review a final order or preliminary injunction. Mm-hmm. Any other kind of order is called an interlocutory order, meaning it's in the middle of the case. Everyone who ever lost a motion to dismiss would love to be able to get right to the Court of Appeals, because it's super important that they win the case and not lose the case.
Yeah.
And it's super important that they avoid discovery and not give discovery. And it's super important that they prove that the judge is wrong and not right. Essentially, Disney argued, well, we're Disney, and it's super important that we win the case and not lose the case. And it's super important that we don't give discovery. Instead of having to give discovery, there is a statute that gives district judges discretion to certify an appeal for interlocutory review. It doesn't necessarily require the judge to acknowledge that she may have made a mistake, but it practically requires that. Mm-hmm. So that's already a big ask. And there is a general strategy in litigation that when you have lost a motion, it doesn't usually help you to lose it again, because by losing it again, you often give the judge the opportunity to clean up any loose ends that may later have later benefited you by raising it to the judge now. This is a similar kind of situation. So Disney said, First Amendment, end of the world, free speech, chilling of things. Judge, you got to realize this is an out there question. You made a call. You got to let us take this up to the Ninth Circuit, because you know and we know that the Ninth Circuit likes us better than you do.
So this is something that Disney would have to request the lower court judge to do. But I read this as, so Disney, and this all started for the audience's sake, who may not remember the specifics of this, right? Disney, like they usually do, they filed a motion to dismiss. This is a stupid lawsuit. We get to do whatever we want because it's the First Amendment. And Judge Garnett, the lower court judge, said, no, I'm disinclined to acquiesce to your proposal because this is
very judicial.
One of my favorite lines from Pirates of the Caribbean was when Barbossa delivers that line. I think that's in the third one, but I've always loved that. So she said, no, I'm not going to dismiss it on those grounds because I think we need to hear more. So that right. You're telling me that the Disney then would have to ask her permission to send it upstairs to the Ninth Circuit, which is, Ron Coleman, when it comes to a political spectrum of extreme left to extreme right, which might be backwards as I'm doing this on camera for the audience, Where does the U.S. Ninth Circus, as Rush Limbaugh used to refer to them, where do they kind of fall on that political spectrum?
Well, to be fair, the Ninth Circuit is freaking ridiculously huge. It encompasses the state of California, states of Washington, Oregon, Arizona. I think there are 45 judges on the circuit court. It is notoriously left-wing, but not entirely left-wing.
No.
But it is true that many of the panels on the Ninth Circuit are out there. This judge, having said all that, is not a Republican appointee. She was, it looked like actually a decently good draw for Disney. And she called it like she saw it, which is fantastic for.
Are we talking about Miss Garnett? Or are we talking about Judge Garnett? Judge Garnett, or okay, I just want to make sure. Judge Garnett versus the appellate court, right?
Well, the appellate court hasn't touched this.
Right. They just
and
said
will
don't
not
want
be touching it for the foreseeable future. In order to make this request, Disney has to make a motion. And its motion says, you made a legal decision here on an unsettled area of law. And the interests here are so profound because of the chilling influence, the chilling effects of associational rights under the First Amendment, that this is a case that the Ninth Circuit should hear before we have to give any discovery. And the first thing the judge said in her denial of this motion to certify the question for interlocutory appeal was, Disney, you've made a mistake here. You have to identify a controlling question of law as to which there is a substantial ground for a difference of opinion that would definitely move the litigation forward if it went the other way. And even then, the judge has discretion. Disney says, well, that's easy. I've got a controlling question of law. It's a purely illegal question whether or not we, as a movie studio, have an untouchable right to decide whether or not our First Amendment rights are affected by an actress who disagrees with our political views. In fact, they say really any ruling under 12b-6, on any motion to dismiss, necessarily raises a question of law. To which the judge says, "What? What are you talking about?" By that logic, that first standard would be an automatic for anyone ever seeking interlocutory review, which is disfavored. No, that won't do. What you're actually looking to do here, Disney, is not to review the legal decision. You're looking to review the way I applied the law to the facts alleged in this case. That is the classic example of what you don't get interlocutory review for. So you haven't identified a freestanding question of law. Freestanding question of law, is there a First Amendment right? Everyone remember, this is a claim that was brought under California's Unruh Act, a labor law enactment meant to protect communists that prohibits an employer from firing someone or taking adverse employment action against someone based on his or her political views or activities. Disney could have challenged the constitutionality of that law. It's an interesting question how constitutional it is, but it didn't do that for tactical reasons possibly, or maybe because it didn't think it would win. Well, that's a tactical reason also.
And I think that's what's interesting. And you mentioned something else earlier about how, obviously this judge, Judge Garnett, felt obviously confident enough to say, yeah, you want to send it upstairs. You want to ask my superiors to review this. Go right ahead. And they did. And they got shot down. I'm paraphrasing, obviously, but that it kind of gives Judge Garnett, who is overseeing this case between Gina Carano and the Walt Disney Company, not leverage, but it gives her a little bit more freedom to know this question has been, by all intents and purposes, settled. The First Amendment thing, it's done. So we're moving on, right? After having an appellate court just waive this request that you made off, it would seem unlikely that if Disney loses this case to Gina, which they might, or settle with her out of court for some type of compensation, but it would seem unlikely that Disney would then have enough confidence to appeal it upstairs based on this same First Amendment argument, when it seems like the appellate court has already said, we're good.
Actually,
What do you think?
I think there's a bit of misunderstanding out there. The only person who has ruled is Judge Garnett. The Ninth Circuit has not. They need permission from Judge Garnett to go to the Ninth Circuit. So the Ninth Circuit hasn't given any kind of endorsement of any kind here.
No, they just waved it off, right? We don't even want to look at it.
No, they didn't do it. In other words, it was actually Judge Garnett who waved it off. Now, there are ways to go directly to an appellate court. Something really outrageous and unconstitutional is taking place. That's not going to happen here. And your question is an extremely good one. But even if it had been the Ninth Circuit that made this decision, it would have been based on whether or not the standards for interlocutory review had been met, and not necessarily on the strength or the merits of the Judge Garnett's opinion. But again, going back to your point, what Disney has done here is given the judge an opportunity. I don't think she needed it because her first opinion was really, really good. But given the judge another opportunity to really clarify what she decided here and what she didn't decide. And it's really very good how she lays it out. And she says the Ninth Circuit is not going to go through a complaint and basically second guess it the way it would on a regular appeal. That's not what interlocutory appeal is for. And by the way, when you say there's a substantial ground for disagreement, that doesn't just mean that you disagree. You have to demonstrate that either other circuits have come out, in other words, other circuit courts or the Ninth Circuit itself have ruled differently from me. If you'd pulled a better judge or a judge you like more,
right,
you would have won. That's not how it works. Defendants have failed to present a pure question of law suitable for interlocutory review. You haven't demonstrated why there's a really good chance that I got this wrong. And she says something really important, and this is important also for Gina fans, including you and I, who want her to win this case, which is that the judge reminded Disney. Let me read this paragraph. Defendants contend that the order, this is on page 7, you're probably looking at the last page. Defendants contend that the order held that the First Amendment does not confer on expressive entities the right to disassociate or dissociate with performers based on their off-the-job political speech. As plaintiff correctly observes, nowhere did the court make such a broad statement of the law. Indeed, the court explicitly recognized that defendants might, with a more developed factual record, be able to prevail on their First Amendment defense. In other words, if smoking guns and dash cams and cockpit recorders all were produced in discovery and they all came out and said, Gina Carano is gonna tank the company. We've got to get rid of her. We've got to make an economic decision here. We don't care about her views, but we do care about box office, and she's poisoned. If every single note was hit like that, she would have a very hard time meeting her burden as the plaintiff of proving a First Amendment violation. But if discovery reveals recordings, emails, conversations, notes, where people say, this witch has got to go. She is absolutely ruining our political standing. It's a bad look for the company to be associated with right-wingers. Now we come into the Unruh Act, and now we start evaluating whether what was done to her was a violation. So the court says, we will not certify for appeal a straw man argument conjured up by defendants in an attempt to create conflict between the order and the case law that was cited.
Yeah.
So the court lacks a record sufficient to resolve the case based on defendants' affirmative defense. And, the other kitchen sink stuff that they throw in to try to argue, it's a Hail Mary.
Yeah.
This motion was a Hail Mary, and the ball sailed right over the end zone.